and I have prima facie, my lord, without the affidavit shown that, my lord,
No.
today, I have not said anything, he said.
Shown
My
that.
lord, today, prima facie, I have shown with the documents of the premises that
I have not held neither in your favor nor against you. So let him deal with your application.
He will.
So why are you scared now?
No, I am not
Why are you
scared at
apprehending
all.
now?
I am not scared at all. I am only, my lord, saying today, my lord, one of the prayers in my application is, because your lordship knows, my lord, this is a partition suit. In the garb of a partition suit, my lord, they cannot change the nature and character of the suit and evict a tenant.
You see, the court has not come to a conclusion. Why are you making these submissions now?
I leave it to your lordship, my lord.
Yes.
And in the meantime, very well, my lord, your lordship will dictate the order. I will, my lord, only say today the situation as it is, it should be preserved.
You see, I don't
They
think
should not induct
I don't
anyone,
think
or if I'm
you
in
are
possession.
you are a stranger. I don't think it is necessary at this stage.
Grateful.
जीतेगा जो मामला है कि affidavit direction पे
Yes,
जीतेगा.
come on the next day, please.
Yes.
Why only one thing, your lordship, why I was submitting that this application is not maintained? Kindly takes the cost.
No. I will not.
I have taken the cost.
Yes, we have taken leave
Very well.
of the court.
If it is defective, I shall.
No.
You see, I am not considering his submissions.
Yes.
You also please make your submissions on that.
Form over substance.
Article 21
আমাদের আরেকটা কোন অ্যাপ্লিকেশন 23 ছিল না?
হ্যাঁ 20 কে বেসিক্যালি পাবলিকেশনের
20 and 23, my lord, both matter.
20 and 23. Yes.
21, my lord, I am for one of the respondents, my lord, led by Mr. Taposh Kumar Sinha. But my lord, before starting the matter, my lord,
Yes. No question of starting. I am passing the order. I have heard entire thing on the last Friday.
No, my lord.
Nothing is left. Please.
No, my lord. My lord,
I have not been hard in opposition.
Whatever you see the order, whether you have been heard or not.
my lord, Mr. Sinha has not been heard.
Lordship had held that I will go through the matter of the opposition.
Yes.
I am not.
Now, whatever submission you make, please make your submissions.
Then, my lord,
So this second round of submission.
What do you?
Every-
the second round.
Everything is recorded here before.
No. I am not interested. This. What submission you want to make?
One, if can I make, sir?
Yes.
Can I make? আমি একটু বলে দেবো.
Yes. I have heard you at length. Why are you just making this prayer? No.
No, my lord, kindly.
I have. You see, I have produced your opposition.
Mr. Sinha's client has not been heard.
My lord, the opposition, that is enough. I have to.
I have gone through your opposition.
That is not sufficient.
Even if you argue, that will not improve your case.
You know, I know. You see,
Very well.
I know.
Very well. You submit.
Certain, my lord, these are certain facts which has to be played.
You see, when a matter is appearing for orders, what is the role of the court? Court has to pass the orders.
Lordship has given a chance, last occasion, then I will go through the evidence in opposition which has been filed by my client.
Very well. If you want to add something, you add.
May I make one submission?
Yes. No, you have made your submission.
I'm not going to make any submission on merit. All I want to say. Your Lordship will kindly see the judgment passed by Justice Patnaik.
No, I have gone through
Your Lordship will see.
everything. I have gone through. Let him make his submissions.
Everything has been dealt with.
Whatever. Let him. Whatever.
I mean, just 2 minutes. Just 2 minutes. Just 2 minutes, then my learned friend will I not interrupt anybody. So that if your Lordship sees the judgment of Justice Patnaik, it deals with all the submissions made by everybody. Justice Patnaik has dealt with everything in his order, in his way. Now, as of now, there is no stay of this portion of the order. Your Lordship is on the second limb now for confirmation of the minutes. Now, as far as the adjudication on the various points, that is done. So, where is the scope of today making further submission?
Let him justify that.
This is all I sit down, but I will not interrupt your Lordship.
Let him justify that. Please. Yes. Tell.
Now, my
30 days they have done this last time.
Last day, my largest senior
No, they
placed
placed
the
30 days
matter
last
the
time.
report of the chairman.
Yes.
Till 6 o'clock.
Well, is it correct or not? I am asking for myself.
Yes.
Is it not the collusion? Is it not the collusion?
You can ask Google.
Report, my lord, this which has been, my lord, placed, who has placed this circular? We are not getting. There was a direction passed by the, my lord, Justice Patnaik to place the report. I play before, at the threshold, I make my submission. My lord, I am entitled to get one copy of the report. based on my lord the report. That report I have not. I have not seen that as on today. Now your lordship going to the final order. Apart from this, now my lord, this the I only want submission before your lordships. My lord, this the appeal against the order of 23rd of April 2025, which has been prepared by one of the, my lord, this the intervener. What order has been passed by the division bench of this court? Division bench held, since a sub res judicata matter is still pending before the appeal bench, section 10 of the CPC, because of the issue regarding the constitution of the committee, that issue is still pending before the division bench in the appeal matter in 2022. Suppressing that fact, they have filed 42. Now, I have taken a preliminary objection without considering the issue which is passed pending before the appeal court, how this order has been passed. Against that order, prefer an appeal. Appeal court held, since appeal, I have come with the all the records and this the order which has been passed by one after another. This is it will be help for lordships kindly come to. This the first issue is this. My Lord Justice Devanshu Bosa, in this matter held, because of the similar facts and circumstances, they try to move an application for getting an order for holding the election. 21st of January 2020, my Lord 1, my Lord Justice Devanshu Bosa held first. Kindly come to. That's sir, আমলাকে আমি ডিস্টার্ব করি।
আরে আমি সিনিয়রের সাথে কথা বলছি, আপনার সাথে কথা বলছি।
তাহলে কার সাথে বলুন? তাহলে
আমি সিনিয়রের সাথে কথা
একটু
বলছি।
আমি ডিস্টার্ব করলে আমি
তাহলে আপনি
পারবো না।
ডিস্টার্ব কানে ইয়ার প্লাগ লাগান।
স্যার আছে, আমি রেসপেক্ট দিয়েছি।
কানে ইয়ার প্লাগ লাগান তাহলে।
Sir, kichu bolche na. So now, my lord, if your lordship kindly come to page 6. So now the 6, my lord Justice Devanshu Bosa held, kindly come to page very vital issue, page 7. The order passed by my lord Justice 22nd of January 2021. There are very many issues where are at the raised by the proceeding. Apparently, a suit is 1872 was filed before this honorable court. The first issue is there with regard to the cost title. Because of that, the cost title 1872, that is that. So now that issue, without considering that issue. Now, second, if your lordship done, they came before this honorable court for permission for holding the trustee board election. Then, without deciding that issue, the matter was withdrawn. Next page, my lord. 5th of March 2021. Page 9. Page 9. That observation till now.
Page 9 is what observation?
Observation is page 8, which has been held, my Lord Justice 7, my Lord Justice Devanshu Bosa. They came before this honorable court 2021 for, my Lord, the permission for holding the trustee board election. My Lord Justice Devanshu Bosa held, my lords, since there is so many, my Lord, the irregularity, amendment, whatever it may be, kindly come to. There are very many issues which are raised in the proceeding. Apparently, a suit in 1872 was filed before this honorable court. The first issue is with regard to the cost title. Kindly see the cost title, page 6.
Yes, page 6.
Apparently, as the
No, is there any observation regarding cost title by his lordship?
yes, my Lord,
Where is that observation that there is a
the
cost
same
title?
does not. Whether the next issue is this: the litigant to the lease being alive or not.
Which page?
My Lord, page 7.
Yes.
Page 7, my Lord, this is the third paragraph. Penalty bait paragraph, my Lord, this
Yes,
paragraph.
yes.
Got it, my Lord?
Yes.
So now this observation still exists.
Yes.
Now they do not get any order. Then kindly come to page 9. GA number 29, this order has been passed.
Yes.
So now this application withdrawn without leave of the court for filing a case. Right? What is the issue before the Honorable Justice?
No, this was the application by the Shevites.
No, Dokkineshwar, this petitioner, my lord, is the person who has come.
No, some of the Shevites are represented.
That means, my lord, the some of the representative, Mr. Brojwat Banerjee, Mr. Nathan, that today who has filed the application 42. Same person has filed. My lord, I am coming next para. My lord, thereafter, a lots of order has been passed by this court. Now, my lord, is kindly come to, since a one after another order passed in a suit which was filed in 1872 for my lord.
You have made this submission on the last occasion. Why are you repeating?
I am not repeating, my lord. I am coming only on that point. So today I have come only on that point, my lord, when a issue is, my lord, this sub judicata, my lord, before the, my lord, this the res sub judicata, my lords, before the honorable division bench, both the division bench. Both the division bench, lordships also probably held, my lord, in another matter because of the, in a criminal proceeding and the civil proceeding does not apply in the section 10. In that judgment, your lordship has considered in the Supreme Court judgment that if it is the civil dispute or civil, in no criminal malada case with connection with the malada, civil suit will be applied in that judgment. In this case, my lord, I have cited one judgment of the Honorable Supreme Court, sir, when the issue is pending, first issue is pending before the, my lord, I have given the list of, my lord, the short notes of document, my lord, page 38, the judgment which has been, my lord, delivered by, my lord, the Honorable Supreme Court, 2013, volume 4, SCC, page 33, paragraph 9 to 12. So now, if your lordship today pass a confirm, then the issue, lordship had taken the jurisdiction of the appellate court. Because of that, jurisdiction of the appellate issue is the same is pending before the, prior to filing the, apart from this, when they have filed 42 filed after, my lord, the appeal, the issue is pending before the, it is not the case that the appeal court has not entertained our application, the appeal matter. Whereas the specific direction, they have taken the plea, maintainability point, suit is pending, how the appeal is maintainability, considering that, my lord, the
No,
submission.
was there any further proceedings before the interlocutory court or suit court was stayed by the any higher bench?
Higher bench has not been, it means, my lord, is kindly, if your lordship, once again, my lords, come to the judgment of the, my lord, order of the, my lord, just division bench, presided over, my lord, Justice Rajasekhar Manta. What hell, my lord? It is para 10, kindly, once again, my lord,
If you have a copy, please give.
my lord, I have given, handed over.
No,
I
no,
have given the,
Just
kindly see, my lord, I have entire, my lord, list of dates, just now, my lord, I have given just now.
give.
I have given, my lord, just now, my handed over.
What the list? Oh, this one. Yes.
Yes. Page 20, my lord, is 36. Why this court has not passed, the division bench has not passed the, my lord, this the interim order or stay order. That does not mean my stay application has been rejected. That
Yes.
what appeared in the, before my lord Justice Bhattacharya, my lord, item number 5, on my lord, last, my lord, this the Wednesday. And now matter heard by your lordships on, my lord, the Thursday. Because of that, on that day, they may approach. This prayer was made, my lord, the confirmation before my lord Justice Manta. No, if any order is passed in connection with the appeal, then conflict order will come. Because of that, if the judgment will come in the appeal matter, that is why my stay application has not been heard by, and that's why they refer the matter assigned by the Chief Justice to the, my lord, Justice Bhattacharya, Sobhasati Bhattacharya. That does not mean, my lord, that my stay petition or my stay, prayer of the stay has been rejected. Lordship has to, my lord, so far my knowledge is concerned, my lord, the judicial decorum, because of that, generally, if the my stay application rejected, your lordship has, cannot, my lord, lordship can, because, my lord, this the returnable date was 9th of June. They have not chosen to approach before lordships or any other court. Just because of the, my lord, just a division bench, circuit bench, they have taken the chance. No, I have given one.
Yes.
So now my respect to submission. If your lordship, my lord, this is the only, my lord, another, my lord, that's application which has been filed by my advocate. I have been served. That is February 2020. That's
I'm confining myself to
But
GA42.
My respect to some consider my written notes of argument. Your lordship may pass any order. Then my lord, this is my respect submission.
No, maybe I'm confining myself to GA42. No other applications.
Well, my lord, in GA 42, I am led by Mr. Taposh Kumar Sinha. My lord, his client filed the appeal against the order passed by
Justice Pattonayak.
Yes, my lord.
Yes. I've gone through that. Yes, anything you want to add?
Yes, my lord, may I appraise your lordship on
Your lordship
one
wants
one
me-
point only?
Yes.
My lord, whatever fallen from your lordship is basically, my lord, is there any stay on GA 42 or not? My lord, my humble understanding and subject to your lordship's correction, my lord. The question is not whether there is any stay on the GA 42. The question is whether there is any stay on the PILs. The PILs are already entertained by the Honorable Division Bench. And this application was filed subsequently after filing of the PIL. The total res sub judice, my lord, the section 10 of the CPC virtually applies in this case, my lord. There is no question of, my lord, of explicit stay in GA 42. This is my only submission, my lord. Can you record this?
Very well. Question is, you see, I'm with regard to in GA42, you representing which party?
My lord, I am representing one of the interveners.
No, GA42.
Yes, sir. GA 42 only. GA 42, I was.
Are you a Shebai?
No, my lord, I am not a.
What capacity you are representing?
Yes, sir. I am a devotee. I am a mere devotee.
You are a devotee. Very well.
Since my lord Dakshineshwar temple, in my humble understanding, has become a public trust, has become a public.
Very well. Those are sub judice before this court that will be decided. You are for one of the Shebaites. One of the Shebaites.
My lord, this is the only one submission I left, my lords. My lord, if your lordship kindly come to page 2 of my written notes of argument. Only understanding before your lordship, my lord, is that what is the, my lord, is very vital. Because of that, a course of rupees, my lords, according to, my lord, the appeal who has been filed. So no, they have not controverted our application. Kindly see the paragraph, page 2 in my. In the meantime, some of the interested devotee, including one of the learned advocate of this Honorable High Court, to file a 2 separate PIL suggestion, thereby praying for following you to constitute a constitutional committee for the said temple. To constitute a scheme a place of the common. My lord, this is the last F to hold an inquiry against one, that is, I will not take the name, his associate for misappropriation of huge fund of the temple. That is the allegation in the PIA. So now twofold. One is the constitution of the committee. Constitution of the committee will come either by way of, my lord, the election, or by under that section, my lord, if your lordship that held, the suit is under section 92 of the CPC. If it is public charity, why a particular family will manage, will come from the
Suit is admittedly not under section 92.
what?
Admittedly, the suit was not under section 92.
Administrative suit under which one?
Section 92 under the public charitable, under the Devattor estate. So section 92 was not there when the suit was filed.
CPC 92 of CPC that had been considered.
No, whether it was under section 92 when it was originally filed.
That is the Malada understanding or adjudicating before the Honorable Appeal Court. So
Appeal court is not adjudicating the suit because the appeal court does not have jurisdiction.
Taken the plain, the entire thing has been taken by the division bench.
Appeal court is usually does not take up
No,
these
whether it
suit
is
matters.
public or private, that is the issue before the Malada Appeal Court. If it is the public, then the Constitutional Committee, like as Kalighat, Surabhi Bose, lordships know well aware. If the Malada lordship know the definition of the public tears, public temple, if you the person, any devotee is allowed to perform their, my lord, the puja, then it will become a public. If your lordship take the 1 paisa donation from any person, then it will become a public. Lordship know better than me, my lord. So now that issue, if it is public, then a constitutional committee, as per the law, will be, my lord, the constituted district judge is the head of that committee. So that issue is still pending.
Okay.
My lord.
You see, let me pass the order. I have heard all of you. With regard to GA 42, I have heard all of you. Now let me pass the order. You see, I have not made out my mind whether I am affirming or whether I am refusing. So why do you prejudge? You see, whatever order I pass, you have a remedy before higher forum, or both of you. That I have to see.
So now, lordship.
Yes, record an order.
And my lord, in all the applications, what we have sought for is, my lord, basically appointment of a receiver. If
Okay.
a receiver is appointed today, let it be Honorable Justice Jyotirmoy Bhattacharya.
Learned advocates for the parties are present. Hard learned advocates. I think no other submissions to be made. Only thing is on the date of passing the order, no further submissions.
No, but I will not.
Okay.
So far my part is concerned, I
Let
will not
this
make.
matter appear for orders.
So much.
23/7/2025. Okay, tomorrow orders will be passed.
My lord, only one submission.
Yes.
My written notes of my lord kindly record. Written notes of argument, my lord. That is only my lord remedy. I will not make my submission tomorrow. Nothing more. Your lordship can pass.
Yes, you
I
have made your
do-
submissions.
Your lordship wants me, I can agree, because all these submissions that were made today were made before Justice Patnaik.
Right.
And
The order will speak. You see, I'll
Order
consider
speaks
the
for
order. If the
itself.
order considers
and
everything.
it considers everything. In fact, today also a submission was made which was rejected long ago by Justice Saraf when his lordship was presiding over this matter. Well, I also have that. But this today, below your lordship was an order of Justice Boshak was placed, and something was made. This was put to rest by Justice Saraf by his judgment dated 30th August 2022, where he has
Give your learned friend that copy. Give me a copy also.
he appeared over there.
But then I
You
will.
give him a copy. Give me a copy also.
Yeah, I'll give your lordship a copy because this is. I'll just place this.
Whatever
I
it
did
is.
not disturb anybody.
I'll go through his notes, his copy. I'll go through your copy also.
Yes, I'll tell your lordship. Would your lordship want to place it?
Yes. Only the relevant portion.
Yes, only the relevant portion. First thing first, the applicants in GA number 31 of 2022, this is the earlier round. GA number so has sought for modification or recalling of the said order dated 10th March 2022. The applicant contended that the court was not apprised of the order dated January 22nd. Today, what was placed before your lordship is that order. January 22nd, 2022 in GA number 29 of 2021, leading to suppression of material facts before this court. However, GA number 29 of 2021 was dismissed as withdrawn on 5th March 2021. This is what Justice Saraf has observed. And the orders passed in it not only is not in existence anymore, but also bears no relevance or the application as far as the present application is before me is concerned. Further, it is GA number 29 of 2021. The judge did not make any observation, and the order therein contained only reflection of the issues raised by the councils. Therefore, in my view, the prayer seeking modification or recalling of the order dated March 10, 2022 ought to be rejected. Next, the council also contended that the order dated March 10, 2022 of this court was passed in a dead suit. Again, that was said by them. Since the original parties were long dead, it is in furtherance of this argument, the council has cited, and I'm not going to the judgments, then the court observes. This court agrees with the party. parties to the original appeal might be dead unless they are over 150 years old, and a world record in the oldest human being to be alive is to be broken. But the material fact of the judgment cited by the council starkly differ from the present one in hand. Thus, this isn't an ordinary suit, but an administrative one under the control of the court. When it comes to administrative suit, the court is at liberty to allow the trustees to apply for implementation of the scheme in connection with the suit administration of the Dakshineswar Temple and Devotta Trust. These are findings of and no appeal has been preferred from this. This has reached finality.
During pendency of the appeal, during
During pendant. Your Lordship, just give me 1 minute. Appeal date tak hobe baba? Ekbar dekhto.
no public interest litigation, during pendency of the appeal,
Yes.
not appeal, appeal.
So, so these issues have reached a finality, and no appeals have been preferred. Ye order copy ekta baat.
The previous committee, you see, the previous committee took charge which year? Previous committee, previously last election held and previous 23. And the order of Justice Saraf,
This is 22.
22. And the appeal filed on which year?
2020.
22.
My lord, this is only one.
No. 22 appeal was filed.
Yes.
23, I believe Justice Saraf's order, no, Justice Saraf's order was,
Yes. Ultimately, Justice Saraf's order is 2023.
Well, after passing this bill has been filed.
No, not after this. Final
My
order.
lord, this-
Final order is after the appeal is filed.
okay, after the appeal is filed, Justice Saraf's order was
Final
passed.
order is
And
passed.
that was implemented, election took place
Yes.
for
Years consecutive was work.
23, 24, for a period of 3
25.
years.
Yes. 25 because the process has to start in because it will take some time. So now after this, the new term will be commencing when your Lordship confirms it.
Yes, so Justice Saraf's order is, I'm not going into the merits of anything. Justice Saraf's order is pursuant to the filing of the appeal and pursuant to Justice Saraf's order, election was held and committee took over the charge.
Absolutely. Great.
No, that is not correct.
এই একটা
My lord,
একটা
that is
কপিটা
not
পাঠ করে
correct.
দিন।
Yes,
My lord, this is the last para. Only the order which has been passed by my lord Justice Saraf for hold a election expert.
That is exactly
My lord,
what
I-
has been passed last time.
My sir, আমি বলি
না আপনি আর কতবার বলবেন রে বাবা? আপনি তো
আপনি
চারবার
তো
বলে
একবার
আমি তো
বলছেন,
আপনাকে
আপনি কোর্টকে যদি বলেন অন্য কিছু আমিও তাহলে আমাকে
okay, the order will speak for itself. My only clarification which I sought is whether Justice Boshak's order was prior to appeal or during pendency of the appeal. This is only the clarification which I sought.
And now what have hail my lord Justice Saraf, hail, only I am not recalling the order which has been passed for holding the election. Only that pair I am
Only-
rejecting.
only
Other
the-
pair is still exists,
So elections order was subsisting.
allowed. Only that part, because of that other pair which has been for constitution of a committee, that part has not been considered para 8.
Anyway,
But let's
that,
kindly see.
anyway, that is still sub judice, that will be considered, that is sub
Yes.
judice.
That is the now.
Okay, give the, if you have a copy, please give.
we don't have it just now. I'll give it to a Lordship.
Okay,
officer.
give.
And taking into consideration, order has been passed in the appeal court.
No stay till date by any court.
No, did the appeal court fetter the hands of any
No.
trial court or any,
No.
that you do not proceed?
No.
No proceedings in the courts will
No,
take place.
no,
Admittedly.
no.
If it is there, definitely no
There is
further.
no fretter.
So this is
If appeal court directs, no further proceedings, heaven except this bill with regard to the trust property, no courts can proceed.
Your Lordship, I take full responsibility and make this submission before your Lordship when I say that no such order has been passed by the appeal court.
Yes.
I admit. No stay order has been passed because of that.
My only question is whether the
Now,
appeal court,
your lordship-
because you sometimes you see division bench or apex court sometimes passes order that yes, no further proceedings with regard to this issue, save and accept. So whether any such order was passed.
Because of that, in law, the section 10 proceeding of CPC has not been considered by any of the court. So this is your
Yes.
lordship can. Section 10 of the CPC.
Yes.
I've got the dates. The two pills that were the public interest litigations were filed. First one is dated 19th of September 2022. The second one is 15th of November 2022. And the final order confirming the last election is dated
27th June 2023.
27th June 2023. That is after the bill.
after the bill.
So your lordship wanted to know the dates, I've given to lordship. So when that order could have been passed and that has not been taken up, so my lord, this is only a consequential to next year's order.
Because even if today there
Yes.
is a direction by the appeal bench, even if today that no further proceeding with
Absolutely.
regard to the
I
transport
will-
7 except this bench,
I'll not approach your lordship, my lord.
then
We have a
court-
dispute with the
court
court.
is powerless. Anyway, I will consider all submissions, then pass relevant orders. After you get it ready, you please file it.
Yes.
And then
Only the
that
30th
is
August 24.
my lord, only one submission, well,
Yes,
notes of my,
Judge,
this is notes of argument.
Yes, yes, I have kept
My
it.
lord, order, my lord, only one word is required. My lord, the notes of argument filed by the, my lord, the intervener or my lord, the opposite party, my lord, that has to be kept.
Yes, by you. That is one of the Shevites. Yes, yes, yes.
My lord, it's only that note. Nothing.
Yes.
30 অগস্ট 2022
Okay. The notes of arguments, order মধ্যে একটা ইয়ে করে দেবেন তো, the notes of arguments, the notes of arguments file be kept with the record.
Grateful to loss.
Yes, that's all. Tomorrow for orders.
Okay.
কালকে 10:30 দিয়ে দেবেন একদম top of the list for orders. ঠিক আছে?
But I will give it in an hour's time and I shall come.
Yes, 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 please. Yes. PM 64 হ্যাঁ ডেকে দিন।
This matter at 2 p.m. item number 64.
Lordship, in this matter, the question is appearing on behalf of the defendant. Then Lordship, mother was demised on the, also kindly speak, 6 weeks time. Lordship.
I am appearing for the plaintiff in this matter, Lordship. This matter was fixed for arguments today. Learned counsel has informed us earlier, Lordship, there has been a demise. We will not stand in the way. Lordship, my only prayer is it was fixed today at 2 p.m. Lordship, may kindly fixes another date and time, Lordship. Not 6 weeks, Lordship. Kindly gives at least 3 weeks, Lordship.
At least 4 weeks. Lordship.
Yes, learned advocates for the parties are present. You are representing whom?
I am for the plaintiff, Lordship.
Okay, okay. A prayer is made on the ground of bereavement in the family of the learned advocate for the defendant. Thus, this matter stands adjourned till 20th August 2000. Okay, 19th August 2025 at 3 p.m.
Grateful, Lordship.
Item number 24.
Grant of plaintiff number 1. On the last occasion, your lordship directed me to file supplementary affidavit annexing those documents which I have gravely.
This is my application, my lord, for addition of party. In connection with the partition suit, I have purchased some share from defendant number 2. By
You are the applicant, intervening applicant.
I'm
You are
the
the plaintiff.
Yes,
applicant, my lord. I have
And this is
purchased-
your application, GA 20.
yes.
My lord, defendant number 2 has sold out some portion of us of the share to me. My lord. He will not, the plaintiff will not be affected in any way. Whatever will be the share of defendant number 2, that will, my lord,
In supplementary affidavit, what have you incorporated?
The orders which I have gravely doing my affidavit in opposition.
Did you use any opposition to this application?
Yes, yes, I have.
Yes. What is your opposition? Let me see that.
Well, I have filed it. And my grievance is, I am challenging the sale, my lord. Because no court, no order has been obtained from the court to sell the share of that. It is a partition suit of 1948. All the shares which have been sold till now with the permission of the court. After making application before the court, when court granted permission, the sale has been
my lord,
executed.
I have submitted a judgment before your lordship, my lord, on
My
the
lord,
first occasion.
and 98, according to them, in 1998, they have purchased. Why they waited for so long to be added as a party?
Okay, let me see the opposition. Hey, opposition to the and supplementary affidavit also.
He is not going to be affected in any way, but my presence is.
Was there any restraint order from the court not to sell any of the shares?
My lord, lordship, if in a partition suit, if any of the parties
That
are
will abide by the result of the.
Yes, nobody can claim any equity.
and
But however, if there is any restraint order, then no sale can take place.
no, till now, all the shares has been sold by way of getting permission from the court. I have annexed those orders also. Plaintiff number 1 have purchased those shares after obtaining permission from the honorable court.
My lord, I have submitted a judgment before your lordship, my lord. On the last occasion, you had to copy the din. Onake dish. 1999, volume 2 Supreme Court cases, page 577. My lord, here, my lord, similar thing, my lord, happened, my lord. The court, my lord, observed that is to be decided in the suit. My lord, kindly see, necessary party transferring penalty of interest of removed party. My lord, got it. Suit filed by appellant against her sons for degree of maintenance and for creation.
That is
of
not a
charge.
partition suit, my lord.
Principle will apply over ancestral property of the family on the basis of consent of the parties. Here, my lord, more grave case. Interim injunction order was passed by court restraining the parties from the transferring the disputed property in favor of any other person till final disposal of the suit. First defendant selling 1/4 share each to third, fourth, and fifth respondent by the registered deeds. Application filed by respondent number 3 to 5 under order 1 rule 10 like us, my lord, for implement as parties to the suit. Dispute as to whether first defendant was a party to the order of injunction in view of his application raising plea that he has not earlier aware of the case and that first the respondent had forged his signature and filed a bogus Bokalandama and obtained injunction fraudulently. Hell, plea raised by the
Which paragraph?
I'm head notes I am putting.
No, read the relevant paragraphs. Why head notes?
I'm reading. That will be paragraph 8. Paragraph 8.
Yes.
The facts set out by us in the earlier paragraph are sufficient to show that there is a dispute as to whether the first defendant in the suit was a party to the other injunction made by the court on 18/8/92. The proceeding for punishing him for contempt are admittedly pending. The plea raised by him that the first respondent had played a fraud not only against him but also on the court would have to be decided before it, my lord. Before it can be said that the sales effected by the first defendant were in violation of the order of the court. The plea raised by respondent number 3 to 5 that they were bona fide transferees for value in good faith may have to be decided before it can be held that the sales in their favor created no interest in the property. The aforesaid questions have to be decided by the court either in the suit or in the application filed by the respondent number 3 to 5 for implement in the suit. If the application for implement is thrown out without a decision on the aforesaid question, respondent number 3 to 5 will certainly come up with a separate suit to enforce their alleged rights, which means a multiplicity of proceedings. In such circumstances, it cannot be said that respondent number 3 or 3 are necessary parties or not proper parties to the suit. So, my lord, this is the analogy, my lord, that I have purchased the property and whether I have rightly purchased, whether I am a my lord, bona fide purchaser without notice, so many things are to be decided and that may be decided in case I am added as a party. Otherwise, I am to file a separate suit.
Now, at the present, you see, preliminary decree was passed.
Yes, my lord.
Thereafter, pursuant to passing of the preliminary decree, the shares were sold in different phases with the leave of the court.
Yes.
And I think you are the plaintiff.
Yes,
I think most of the shares are transferred in your favor.
Yes, my lord.
Save and except one of the defendant instead of transferring to you, have transferred to Mr. Chakraborty's client
Notice,
without any notice, without
to
any leave from the court.
leave from it. Yes.
So now the dispute,
Hmm.
you see, without prejudice, whether he will be added or not.
Hmm.
Now the dispute, if Mr. Chakraborty is added,
Hmm.
will be between you and him.
Yes, my
All the other defendants have sold their shares.
He has remedies under the law. My lord, in
No, no.
partition-
My
Question
lord-
is all the defendants have sold their shares. Only
There are two defendants. One is my mother have purchased share from one party, and Khatija Begum's share. He is claiming that he has purchased the share of Khatija Bibi. But if your lordship can go through the
no. These are all substituted defendants. This 1A,
Yes, yes.
2A, and all these things.
no 2A, they by now 2A, 2A1 and 2F has sold their share to one Javed Akhtar. And
Okay.
deed has been Javed Akhtar and Faisal Parvez are cousin brothers.
Well, under the partition act, my
Okay.
lord, they are-
Now the question is, you are representing which plaintiff?
Plaintiff number 1A.
1A.
Yes, my lord.
Okay. Faisal Parvez.
Yes.
Oh, this is your supplementary. Okay. Faisal Parvez. You are representing Faisal Parvez.
Yes.
And the applicant, what is the name of this applicant?
Khatija Bibi was the defendant number 2, but lordship will kindly see who has made this application.
Rahmat
Rahmat Rashid.
Rahmat Rashid.
So, my lord,
Lordship will kindly
So
see.
this
that
is the purchaser and intervening
I
applicant.
have challenged the deed. I have called upon them to produce the original deed before
if
your
he
lordship.
challenges my deed, my lord, then I have the right to contest my challenge.
I have
without-
challenged it in this affidavit, in my
That
affidavit.
cannot be.
In my
It's
affidavit,
order
I have
one-
called upon them to
my lord,
produce the
order
original.
one,
Because
rule
what happened,
application For addition of party. My
many
lord,
times they have claimed that
No,
they
no.
have
If you have,
purchased,
if you
but
have
they
the
have not produced that deed before the receiver also. Receiver also asked them to
Right.
produce the document.
my lord, whether my challenge.
And who has sold? On
My lord,
Lordship
my
will
right,
kindly see.
my right cannot be decided in while hearing application. of
in the deed
no,
there is
question is, if you have purchased, okay,
what prevented
and
them
the
so long?
so there is no difficulty to produce the original deed before the receiver or any.
No, I produced the, I shall produce there is no difficulty.
Lordship will kindly see the date of the
remedies available.
execution,
So
1998.
you are ready and willing to produce the. Have you disputed their
Lord.
deed, the genuineness?
Why I have
No. Regarding the genuineness of the deed,
Yes,
which paragraph?
I'm doing that.
Out of the annex করেছি।
No, you have annexed. That is why I'm asking her.
Let him,
Which paragraph you have
I'm
disputed?
telling
let him search before the registry office, my lord.
why I shall go on.
Oh, why?
Why?
Let him search out.
Yes.
Deed is there, number, volume, everything mentioned. Money receipt is also.
Yes. Which paragraph you have stated regarding the disputing the deed?
My lord, paragraph 6
Paragraph 6,
of my affidavit, my lord.
page 8,
Yes, 10, page 10, my lord.
Is
page 10,
Hmm.
paragraph
I
6.
said that
Yes.
even if the defendant number 2 actually sold her share, the sale is not valid because no permission was obtained from this.
So
honorable court for
validity of sale, that is a question of law. Okay.
Yes.
But
And
have you disputed that this is not the sale deed? You are not relying. You are.
I further say that indenture is defective as there is no mention in the deed about the same is being executed through her power of attorney holder. Lordship will kindly see the signature. There is no signature of Khatija Bibi in the.
power of attorney holder.
If a power of attorney holder signs, it has to be signed as by the constituted attorney. That is also not there.
I shall place myself before the box. You will examine me. You will verify me.
So
Testify.
date of execution when?
1998, 12th December
I shall
1998.
face the
98.
cross-examination.
Yes, my lord.
I shall face the cross-examination.
So this applicant did not produce it before the receiver.
No,
Only his allegation is that, my lord, I have not brought the permission. My lord, in
No,
fact,
that's a question of law regarding factual aspect.
aspect.
Indenture is defective. Where is the, let me see the document, which page?
My lord, I have annexed with the
Yes,
page
page.
10 and
Page
10,
Lordship will kindly see
10
10.
onwards. Page 10.
between Khatija Bibi, daughter of Ghulam Muhammad, there is no description that this sale is being
এইভাবে order on rule.
sold by
While hearing petition.
the constituted attorney.
A validity. of
Okay,
the
which
deed.
page, which page you are relying upon?
Page 10.
Page,
In the,
page 10.
starting that this indenture made this 12th day of November 1998 between Khatija Bibi, daughter of Ghulam Hossain Ahmed Oraji, such and such, care of Muhammad Arif. Nothing has been mentioned. This is being sold by the constituted, going to be sold by the constituted attorney. In the last page, constituted attorney has signed.
Why, in the deed, it is not required to be said.
Who said?
I say.
It is not
Constituted
correct. What
attorney
you are
of,
saying.
okay, constituted attorney.
Yes, my lord, last page, my lord, like page number 9.
There is no mention that he has
My
been
lord, it is the
given.
the best person who has, being the vendor, will say whether he has appointed constituted attorney or not. My lord, my learned friend's client is not the appropriate person to challenge the
Why?
validity of the deed. The person
Who said I cannot challenge?
Yes,
I am the
yes,
plaintiff.
the vendor of my
Anyway, there may be defect in the deed, but whether are you disputing the genuineness that this is a fabricated
It's a
document?
defective deed. I've said
Maybe
it's
something
defective.
defect, maybe it is not drafted properly or some description
Yes.
not given.
My
But the
vendor
question
will
is,
say that
you are not
whether-
disputing the genuineness.
Yes,
We do not know whether it has been
that
given
was decided in the suit.
How can
Given-
you see?
because there is no, they have made no application from the before the court to get permission.
That is a
That is
point.
the main point.
That is a question of law.
Yes.
Okay. Now the question is regarding genuineness of the document. You have not said.
My
Only you have said some defects.
Yes.
My vendor will say that I have not appointed this person as the constituted attorney.
Yes, record an order. Learned advocate for the applicant intervener and learned advocate for the plaintiff are present. GA 20 of 2024 is taken up for consideration. Heard learned advocates. Hearing is concluded. Let this matter appear for orders on P8 28/2025. Yes, your reply, you have filed your reply also? Affidavit in reply?
Yes. They have filed.
My lord, if I am not added, I shall be seriously prejudiced, and he will not suffer any prejudice.
My lord, since 1998,
will
he
not suffer
he was
any
sleeping,
because he has
and now they have wake up and they will
Partition Act, so many.
they will file prejudice. They will be prejudiced if not added.
এটা 2nd আগস্ট, হ্যাঁ, এটা রেকর্ডটা পাঠিয়ে দিতে হবে। আচ্ছা, 3 PM ম্যাটার কোথায় আছে? ও 3 PM ম্যাটার আছে। কত নম্বর আইটেম 3 PM?
2nd August for orders.
45 3 PM আছে। দেখে দিন আইটেম 45 টা।
For orders on 2nd August.
2nd August।
Deeply obliged.
দেখে দিন, yes, 3 PM।
But
At
before
3 PM,
before the 3
item
PM
number
matter is
45.
fixed.
Yes, 3
Before
PM।
before the 3 PM matter is called, item number 27 and 28, there was only direction for filing affidavits. She wants extension in one matter and filing affidavits.
Affidavit opposition in CA 66, Lordship. Only the difficulty is that in 67, we don't have the copy of the print, Lordship. I was praying before your Lordship, if your Lordship pleases to direct them to serve a copy.
They will write a letter. I will give him the copy. I will give her the copy.
27, what do you want?
My lord, extension of time to file the.
আচ্ছা, 27 এ অর্ডারটা রেকর্ড করুন তো।
My lord, if they.
Learned advocates for the parties are present. Let
And the
this
opposition is
matter
heard.
appear on
66. My lord, I have served the copy. in the
30th
court.
July 2025. The time to file affidavit in opposition to GA3.
See,
GA4.
CS 67.
That is 28, item
No,
number
no, no,
28.
no. Which GA you want to file affidavit in opposition?
GA4 of 2025.
GA4 of 2025.
Yes, your lordship.
GA4 of 2025 stands extended till 29. Oh, you want to file your reply also?
Yes.
Stands extended till 28/7/2025. Reply, if any, by 30/7/2025. The matter will appear.
In 2 days.
Okay, reply, if any, by 31/7/2025. Let this matter appear on 1/8/2025. ওটা ওইটা না করে 1/8 করে দেবেন।
This order may be passed in item 28 and item 27 they are filing the opposition.
Your lordship.
They are filing the opposition.
Opposition.
In item 27.
CS 66. It is
No, no, you see, CS 66 regarding GA4, I have extended the time.
But
File affidavit in opposition.
no, my lord, they are filing opposition in item 27, that is CS 66, and they are paying for time in CS 67, that is item number 28.
Okay, now with regard to item 27, GA4, I have extended the time to file the affidavit in opposition.
But they are filing the opposition today.
আচ্ছা যাক ওটা কেটে দিন অর্ডারটা 27
That will be passed in, that may be passed in 28.
কেটে দিন 27 এ learned advocates for the parties are present. Let affidavit in opposition filed in GA4 of 2025 be kept with the record.
And I've got a copy today.
Okay, let reply be filed by 30th July 2025.
But a week's time may be needed because the client is
30th July.
Yeah, 30th.
Let this matter appear on 1/8/2025. So the previous order be passed in 67.
In 67, item 28.
আচ্ছা এর আগে যেটা বললাম সেটা ওই আইটেম 28 এ করে দেবেন।
Deeply obliged.
আর 27 এ যেটা এখন বললাম
28
আর আগেরটাকে 28 এ ঢুকিয়ে দেবেন।
Deeply obliged.
Your lordship, in item numbers 25 and 26, I
66.
In this matter, my lord, I am appearing on behalf of the petitioner, your lordship. It's my
It will be
application.
taken up on the next day. Now I am
Your
just
lordship.
taking up the fixed matters.
praying for 2 weeks extension of time to file my affidavit in opposition. I'm the plaintiff, your lordship.
Which case? That is item 25.
Item number 25, your lordship.
Item 25, your lordship.
26 also, both the cases.
And
I am
my,
praying for extension of time to file my affidavit in opposition only in GA 15.
Acha, item 25 এ লিখুন, learned advocates for the parties are present. Time to file affidavit in opposition in GA 15 of 2025 stands extended till 30th July 2025. Let this matter appear on
Your lordship, 2 weeks time because the person who is going
Acha,
to affirm the
30th July na?
affidavit, his
ওটাকে
time
ওটা
has
দেখে-
expired, your lordship.
Okay, by 7/8/2025.
7. I'm grateful to your
Let
lordship.
this matter appear on. Acha, reply if any.
Yes, your
Reply
lordship.
if any by 12/8/2025.
So meager time, your lordship.
14/8/2025.
14/8/2000. I'm grateful
Let
to your
this
lordship.
matter appear on 18/8/2025.
I'm grateful to your lordship. And your lordship, in respect
26.
of item number 26, it is filed by.
Okay, there is no GA. Oh, GA 16 is there.
Yes, your lordship. But your lordship, we are the tenant in respect of room number 27. But
Now,
we.
whose application is this? GA 16.
This is not my application, your lordship.
Who is the applicant?
GA 15
Acha, anyway, let this matter, item
Yes, your
26, let this matter appear on.
also appear on that.
Along with this,
Let
yes,
this
your lordship.
matter appear on 11/8. No, sorry, 18/8/2025.
18/8. I'm grateful to your lordship. I'm grateful to your lordship.
Yes, call the 3 PM matter.
Item 30, my lord, I have the instruction to withdraw the suit. I am for the plaintiff. Kindly, my lord, let it come up any day as to be mentioned.
You are appearing for?
My lord, I am the receiver. I had made a formal application for discharge when the suit had been dismissed earlier. In 2023, it was dismissed.
Now it is restored.
It is restored, but the order which appointed me has not been restored. But
Automatic, that is, you see, receiver unless discharged, will
my lord,
continue.
it will depend on, with due respect, my lord, it will depend on the order.
Yes, because is there any specific order discharging?
If they are withdrawing the suit, my purpose is served. But the only thing is, there is some money lying in the bank.
Anyway, you just take instructions and you apprise the court. I'm keeping it next week.
My lord keeps it after next Wednesday.
Acha, item 30, let this matter appear on 2nd August, 2nd August, working Saturday, 2nd August 2000.
Working Saturday.
Working Saturday.
My lord keeps it 1st August.
Okay. Letter appear on 5/8/2025
30.
under the heading to be mentioned. Yes, 3 p.m. matter. I think both of you have made your arguments.
The Lordship's desire was that we should file our written notes. I was on the question.
Yes, only written notes is left to be filed.
No, Millard. When I was making my submissions, your Lordship's view was that the written notes, because on that day it might come back to your Lordship, Millard. I had cited the order of the Court of Appeal. And the Court of Appeal, Millard, was passed in an application in GA8.
All these will be within your list of dates and compilations. Whatever orders you are relying upon, it should be within your compilation.
Petitioner চেয়েও বেশি মোটা। দারুণ লিখেছিস।
Millard, it's there.
June 17
And Millard, the two notes, your Lordship, Millard, by your Lordship's order of 17th of June 2025, directors asked to file two notes.
No, one is with regard to that is GA.
9.
One is with regard to, I believe, one is with regard to GA9. Okay. The other is with regard to your justification why GA8 should also be heard with GA9.
No. My justification is that, Millard, why the preliminary point should be
Yes, that is
decided
your
first.
GA8. Why GA8 should also be heard along with GA9. That is your justification.
That is my argument, that the outcome of GA8, which is, Millard, disposed of, Millard,
Yes.
was that the Court of Appeal ultimately said that so far as the suit is concerned, any interlocutory orders to be passed in the suit, first the preliminary issue has to be heard. And Millard, that I had said is that if that is the order that is subsisting between the parties and the Supreme Court has not touched the said direction, then, Millard, it is incumbent, Millard, upon any of our courts who wants to hear any interlocutory application to hear out the preliminary issue.
That is what you see. That is
Yes,
covered by your.
yes.
That is covered
And
by your
Millard,
arguments. That is your justification.
And not only that, Millard, it might come back to your Lordship, Millard, that when they wanted to get GA9 heard, so
GA9 was argued at length.
Not before your Lordship, Millard, before your Lordship.
No. I have heard this matter, GA9. Mr. Court's application.
Same lines.
Millard, if your Lordship takes the order, copy, other side.
আমাদেরটা দিয়ে দাও। আমাদের রিটার্ন সাবমিশনটা দিয়ে দাও।
তিনটে দিয়েছি জোসেফ,
বাকিগুলো জাজমেন্ট।
But our written submissions.
Kindly take page 111 of my notes. Hey, page 111.
111 তো একটা
মিলছে না।
Lesser's covenant.
111 is the citation.
Justice Patnaik's orderটা তো অনবাব হতো। তাহলে তো পাতা ঠিক করাতে
নেই
186।
আচ্ছা।
মাথাটা ঘুরে গেল। মাথাটা ঘুরে গেল। ঠিক আছে। না রে। Will it kindly come to page 186?
Page 186.
Yes.
So which volume?
Millard, there is only one Millard, which is
186.
186.
They are
No, the compilation, convenience compilation, which I have prepared for the court, Millard, and I have handed up to my lord.
Okay, this is GA. Okay, this is GA8. GA9.
Should be GA9.
GA9 186.
Yes. Millard, your lordship sees, Millard. The matter is appearing under the heading to be mentioned. Has my lord got it?
Yes.
An application being G8 of 2023 was filed by the defendant seeking the following reliefs. Order be passed. This was our application in G8, the prayers. The aforesaid application was dismissed by a coordinate bench of this honorable court. Challenging such order, APOT 68 of 2024 was filed by the defendant before the honorable division bench. I'm sorry, ma'am.
Page 187. Yes.
On 10th April 2024, APOT 68 of 2024 was disposed of with the following direction. If the suit has become academic and infractuous, it goes to the jurisdiction of the court. The court would no longer retain jurisdiction to adjudicate it. Once it is a jurisdictional issue, it can be tried as a preliminary issue before all other issues. This preliminary issue may not be only an issue of law, but an issue of fact and rolled into one. Pursuant to the order of the appellate court passed on 10th April 2024, following directions were issued by a coordinate bench of this honorable court on 24th April 2024. Since GA6 is pending, liberty is given to this court to decide in order the preliminary issue or the pending application is to be entertained. Since preliminary issue relates to the very authority of this court as observed by the division bench above, this issue should be addressed first. If this court is bereft of its jurisdiction, then any order disposing of GA6 of 2022 a priori might be infractuous. I agree with the submission of Mr. So-and-so in this respect. Since it is the mandate of the appellate court that preliminary issue of the jurisdiction of this court shall be decided first, the issue ought to be framed at the outset. Therefore, that purpose necessitates inquiring as to whether a written statement is filed or not. The learned register so-and-so shall furnish a report on or before the returnable date as to the date of service of summons and so-and-so. An order be passed by the 10th April 1968 was appealed from before the Supreme Court in petition SLP number such and such. Upon hearing, the following order was passed by the Honorable Supreme Court. Heard learned counsels for the parties, having heard regard to the facts and circumstances of the present case, we are not inclined to interfere with the impugned order and the order passed by this High Court. Nonetheless, we clarify that the trial court single judge shall be at liberty to proceed with the suit itself, that is the hearing of the suit, in accordance with law, having regard to the developments which had taken place pending the suit. Both the parties shall also be at liberty to file appropriate proceedings before the trial single judge as may be permissible under the law, and if such proceedings were filed, the same may be considered without being influenced by the observations made in the impugned order passed by the division bench. We further clarify that we have not expressed any opinion on the merits of the case. Subject to the above, special leave petition is allowed pending applications. Mr. Swanson and its counsel appearing on behalf of the plaintiff submits that the plaintiff filed an application being GA6 of 2022 claiming occupation charges which should be heard pending decision with regard to the preliminary issue relating to the jurisdiction of this court. On the contrary, Mr. Banerjee, learned counsel advocate for the defendant, submits that the order of the appellate court passed in APOT 68 of 2024 directing for deciding the preliminary issue relating to the jurisdiction of the court at first is upheld by the Honorable Supreme Court. More so, the jurisdiction of the court being a preliminary one is to be decided at the first instance before deciding any other issue. He seeks that the date be fixed for framing of a preliminary issue as to the jurisdiction of the court, taking into consideration GA8 of 2023 and the affidavits as directed by the Honorable Division Bench in APOT. It is found from the aforesaid order that the Honorable Supreme Court did not incline to interfere with the judgment and order passed by the Honorable High Court in APOT 68 of 2024. Liberty was granted to the parties to file appropriate proceedings as may be permissible under the law. It is informed that no such further application proceedings have been filed by the parties. In view of the above, since the appellate court observed that once it is a jurisdictional issue, it can be tried as a preliminary issue before all other issues, it would be appropriate to try such preliminary issue at the first instance pending GA6 of 2022.
What was GA6 of 2022?
The same identical relief, Millard. It was same occupation charges for a previous period, and GA9 is a occupation charges for the subsequent period, which had lapsed, Millard, during the pendency of GA8, Appeal Court, Supreme Court, and all. Identical.
So GA9 is pursuant to the order of the apex court.
Yes. GA9 they are claiming is pursuant to the order of the apex court. But Millard, what I am trying to impress upon the court is whether it is GA6 or GA9, the nature and manner of the application and the reliefs claimed are the same. So if GA6 can't be heard, because without deciding the preliminary issue, the same should apply to GA9 also.
Regarding GA6 of 2022, whatever there was order, I think as per the application, that was complied with.
No. GA6, Millard, was when GA6 was being heard, we took out an application being GA8. We said that GA6 cannot, no order should be passed in GA6 because the suit has lost its force. Now, Millard, for the purpose of that can be done by two ways. One, by opposing GA6 by via affidavit, or Millard, I have to take out an application because my prayer has to be there before the court for rejection of the plaint.
Yes.
So, Millard, pending GA6, we filed an application GA8 seeking rejection of the plaint on the ground that the suit has spent its force. The appeal court, we traveled to the appeal court and to the Supreme Court, where the Millard court has held that in this case, there is a question of jurisdiction of the court to hear and proceed with this suit. And therefore, the court, Supreme Court, Millard, expressly said that any application, if it is taken up, the court can hear the suit itself. Or, alternatively, decide the preliminary issue. Today, Millard, what I am trying to say before your lordship is, Millard, what my learned friends' clients could not get in GA6 by virtue of this order, he cannot get it by way of GA9. Because GA6 and GA9, the cause of action is the same, only the period is different.
So GA9 includes GA6.
And in fact, Millard, the prayers in GA9 are large enough to include the prayers. Suppose, Millard, in GA6, they are claiming rain from January to April. In GA9, they are claiming from January to March, to July. So it includes that prayer. So what you can't do directly, you cannot now take out an application and try to do it indirectly. So, Millard, I was beseeching your lordship, Millard, and that is where I started, that kindly, Millard, all the papers are before your lordship. Millard, at least decide on the preliminary issue, which, Millard, the court has decided, because without crossing that hurdle, Millard, which is touching the jurisdiction, it could have been any other point, Millard, keeping aside that the court could proceed, I could have understood.
No, jurisdiction means, you see, not a question of territorial jurisdiction or inherent jurisdiction. Jurisdiction with regard to the maintainability.
Jurisdiction as to whether the cause of action survives.
Anyway, that is the question.
So if the cause of action does not survive, then Millard,
if it is court is lack of inherent jurisdiction or other jurisdiction, definitely court has to decide first.
Yes.
But court has jurisdiction to try the suit as in accordance with the merits.
Your lordship is looking at it from the point of view that I can try the suit and I can dismiss it. That
No,
is exercise
question
of
is, you see,
jurisdiction.
suit means what? The court does not have inherent jurisdiction. First, the court has to satisfy with regard to the inherent jurisdiction. Then only the court will proceed further.
Yes.
Now, when there is no question of inherent jurisdiction, court in the exercise of this jurisdiction will decide as to the merits of the suit. If the suit is not maintainable on merits, the court will dismiss it.
So therefore, Millard, the question is, if something, Millard, now that the Court of Appeal has framed it as a preliminary issue, so Millard, it is incumbent, Millard, now to have the preliminary issue heard. Because if the preliminary issue succeeds, then Milord, no amount of order could be passed either in GA6 or in GA9. And that is the reason, Milord, why I was saying that the order of the Supreme Court also gives your Lordship. I don't need the order of the Supreme Court. Your Lordship has the jurisdiction to hear out GA6 also, the preliminary issue also. And I had actually, Milord, started to argue on those lines when your Lordship wanted to be first satisfied as to whether your Lordship wants to hear GA9.
No, GA9, you see, while arguing GA9, you have both argued on the merits as well as with regard to the maintainability and with regard to the orders of the appeal court, the Honorable Apex Court, as well as the earlier application. All you have submitted. So I requested you to put it in your written notes of arguments. First of all, with regard to GA9, which is Mr. Court's application, and second is your justification why GA8 is to be taken up first.
GA8 can't be taken up first, Milord, because
No. Why
it is this? The order that has been passed by
yes,
the
that is with regard to. No, you just pointed out that GA8 should come up in the list along with GA9.
The reason why I did so, Milord, was
because what was the issue in GA8?
Yes, to apprise your Lordship as to what was the scope
justification to consider this application and try the maintainability first, thereafter proceed with GA9. As well as you have dealt with on merits also.
Absolutely.
So this is okay. One is with regard to the merits of GA9, I believe. No, this is GA8.
On the question of jurisdiction, Milord, there is one line at page 171. At 171 of the appeal court order, Milord.
Yes.
Milord, the first paragraph. This is what the appeal court has said. If
170.
171.
171. Yes.
If the suit has become academic and infructuous, it goes to the jurisdiction of the court. The court would no longer retain jurisdiction to adjudicate it. So this is inherent. Once it is a jurisdictional issue, it can be tried as a preliminary issue over all other issues. The preliminary issue may not be only an issue of law, but an issue of fact and law rolled into one. I am saying that so far as this preliminary issue is concerned, if your Lordship sees the scope of the suit,
yes.
If you see the scope of the suit that has been pending, the orders that have been passed in the suit from time to time,
yes. Yes, this is the observation. Justice Mojumdar's order is also there.
Yes, Milord.
Since it is mandate of the appellate court.
Yes. All the coordinate benches, Milord, have unanimously held that the preliminary issue has to be decided first. And your Lordship is not in any different situation.
Anyway, you have referred to relevant orders past.
Well, at the relevant orders, they passed that, at page 173 is Justice Mojumdar's order.
Yes, that I was going to.
Yes.
Yes.
Division bench is at 168.
Yes. This is there.
Yes. And 186 is Justice Patnaik's order after the Supreme Court order.
186.
Yes.
Okay, that's all.
Now, my lord, only two things. GA6, my lord, your lordship wanted to know what was the prayer in GA6 and what is the difference between GA6 and GA9. And I told your lordship it's only the number of months here and there. Kindly, my lord, come to the prayers in GA6.
1-0 master's 121 petitioner.
120, my lord, your lordship comes.
Page 120.
Yes. This is, my lord, the master summons in GA6. My lord. GA9 है पे
লিটিগেশনের গোচরপত্র করবে
করবে
করছে লিটিগেশনে করবে আর বক্তব্য প্রধানমন্ত্রী বলছে তোমরা নিয়ে দাও আমাকে ছেড়ে দাও কিন্তু থাকতে না কি করবো তো লোককে ঢুকিয়ে দিয়েছিস ভেতরে নিয়ে কি করবো বল কি করে টাকাটা আদায় করবো আমি তো বক্তব্যেও বলেছিলাম যে আপনি সারেন্ডার করে দিন তার পুরো প্রবেশন আছে
So this was GA6.
This was GA6.
Yes.
And kindly, my lord, see GA9, the one which my lord, my learned friend's current application.
That is page.
That is, my lord, another application. GA9 and master semester in.
এখানে হবে
GA9 এর GA9 এর
এটা GA9 টা দেখুন।
আমি তো
GA9 এর মাস্টার সামাজটা
সারেন্ডার করে দিচ্ছি। যদি আমাকে মিন প্রফিটস থেকে ছেড়ে দাও, সারেন্ডার করে দিচ্ছি। সারেন্ডার করে দিলে অর্ডার 2197
এই পিরিয়ড ভাড়াটা দিয়ে দেবো
সেটাই তো হচ্ছে না, সরকার তো জানো তো
ভাড়াটাও দিবি না, তোরা চলে যাবি আর আমি টাকাটা নিয়ে আদায় করবো।
Yes.
প্রথম দিনই বলেছিলাম সারেন্ডার করবি না। না হয়তো আমাদের প্রতিদিনে হয়তো হতে পারে, বাকি
জিজ্ঞেস করবো কতটা আছে
তো সেটিল করে ফেলা। 14 বার বললাম সেটিল করে দিতে। মাই ক্লায়েন্ট হ্যাজ নো ইন্টারেস্ট ইন দিস লিটিগেশন বাট হি ইজ অনলি ফেসিং বিকজ আমাদের চাপ।
Yes, GA9.
Your lordship will find kindly compare Millard from prayer G of GA6 and prayers from GA9. Lordship gives me a moment.
This is GA9 and page GA6 is page
GA6 page 122.
122.
Millard from prayer G, apart from those usual prayers of certificate, substitution, recording the death, first the prayers surviving Millard in GA6 are from prayer G onwards at page 122.
Yes, that is
respondents be directed to remedy the breaches committed in intention such and such, paying and disbursing outstanding service tax on rent amounting to 50,000, 50 lakhs towards reimbursement of service tax, paying entire area of municipal tax along with interest penalty as may be due and payable, and producing receipt, disclosing the names and details of sublettees so and so, paying outstanding lease rental occupation charges from December 2009 to May 2022 amounting to such and such, along with interest. And my lord, here is defendant be directed to pay such and such rent charges from December 2019 till February 2025 to the principal within a period of 7 days, and in the alternative, my lord, directed to deposit and secure before this honorable court, and the same reliefs. There, my lord, from 9 to 22. Here, my lord, it's from 22 to 25, 19 to 25.
So the question is, if GA6 cannot be taken up, whether GA9 can be taken up.
The same prayers. And the courts have held previously, my lord, that GA6 can't be taken up unless the direction of the appeal court is complied with, which is hearing out the preliminary issue. Now, my lord, as I understand, my learned friend tried to bypass this by contending that GA9 is an application subsequent to the Supreme Court order.
Let us once more take Supreme Court order, page 176.
184.
Page 178.
কি করতে চাইছো তুমি? Ball are sailing through or underneath. কি করবো?
Yes.
So, my lord, Supreme Court didn't give him a right, saying that no, all the subsequent or previous orders, you still have a fresh. I can understand, my lord, at the highest, you don't require a blessing of the Supreme Court, my lord, to file an application in a suit. At the highest, it can be construed that you have to have a subsequent cause of action, a fresh cause of action as a reason, which requires you to file an application. You are at liberty to file it in accordance with law. Now, in accordance with law has to be read, my lord, with the first portion of the order, which upholds the order of the apex of the division bench. So, read harmoniously, my lord, it would mean that if GA6 cannot be heard, the same reliefs in GA9 cannot also be heard. Because what is staring at the face and what is at the root of all this is the jurisdiction of the court. And even the Supreme Court, my lord, your lordship will find, has very clearly stated that nonetheless, we clarify that the trial judge, my lord, at page 184, single judge bench, be at liberty to proceed with the suit itself in accordance with law, having regard to the developments which had taken place pending the suit. What are these developments? My lord, these are the developments, my lord, which take it way beyond the four corners of the plate. My lord, it might come back to your lordship, my lord. I had argued before your lordship that the eviction notice was for defaulter for a particular period and for a breach of a clause which compelled me to which was my obligation to construct the building. Thereafter, my lord, when they terminated, my lord, there was an order passed by consent that consent order enhanced the rent as well as the period for which the construction will go up. So, my lord, the moment the parties consent to a further enhancement of rent, that means the previous eviction notice is no more enforceable. Thereafter, my lord, that time was again extended.
That is with regard to maintainability, you are
correct. So, my lord, I was trying to impress upon the court, my lord. In fact, I will be beseeching your lordship, my lord, that kindly take up this preliminary issue and dispose it off.
okay. Before going into this GA9,
Because GA8, GA9, GA6, all these will come to an end. And my lord, I can say this, my lord, bolbo to? Your lordship, my lord, with the permission of Mr. Kaur, I am saying this, my lord, your lordship can bring an end to this dispute once and for all. I'll tell your lordship, my lord, where the shoe is pinching. Mr. Kaur's client is the owner of the property, the Devotto Sampatti. I'm not disputing it. The fact that today I am not in breach of what the suit complains of cannot be disputed by Mr. Kaur. That dispute is no more there.
I am disputing that.
Very well. If he is disputing it, he is disputing the fact that I am still in breach because the construction has taken place. Now, there are two issues. That lease, my lord, permitted me, my lord, to let out. To let out. I have let out the property to various persons. What was happening between all this period was, my lord, this third person through whom, my lord, the construction had taken place and the persons are in possession, my lord, they were paying rent to me and I was passing on the rent to Mr. Kaur. This situation went on till 2019. Till such time, my lord, the COVID intervened and whatever reason, my lord, for the Akriti, the third party, my lord, who is not there, didn't pay us. At one point of time, my lord, it occurred to the court in this litigation that Akriti should be heard. And they also made an application, my lord, for being added as a party. But subsequently, they did not turn up. And the application got dismissed. Now, my lord, the situation is this. I am a government company. Andrew Yule is a government company. I am not enjoying any portion of the property, save and except, my lord, receiving the rent and passing it on in its entirety. Now, my lord, all it is required, my lord, today is that I was telling Mr. Kaur, if the parties could sit down and talk about a settlement.
There, you see, on this issue, the matter can be sent to mediator also. That option is always there with this court.
In that mediation process, my lord, I think we too can mediate because I have all.
Instead of both party mediation, let there be an intervening person who will be in a better position.
No, what I'm saying is that mediation,
that would be more fruitful than both parties sitting for discussion.
I think, my lord, with
Mediation
respect
between
me and
his client and my client.
That is not a mediation. That is a settlement discussion.
That can't happen because he is not willing to pay the rent. He can surrender. He can submit to a decree. That is what it can happen. But he is not willing to pay the rent. That is the main problem.
Because the rent at till date was being paid by third parties.
Lord, kindly hear me for 5-10 minutes, Lord, in reply. I'll finish off, Lord. I believe that your lordship
Anyway,
has...
now Mr. Datta has submitted on with regard to why the preliminary issue should be taken
Yes,
up first.
I'll make my submission.
And why not your application?
Yes, I'll make
now
my
you
submission.
justify.
I'll just make my submission.
Oh,
Lord,
one.
Yes.
My lord, GA9 এর নোটটা দিন তো।
This is GA9, yes.
Kindly নোটটা নিন।
Okay.
My lord, kindly come to page 29.
Yes.
My lord, your lordship will find I have relied upon a judgment of Asma Latif and another versus Sabir Ahmed and others. Kindly, my lord, come straight to paragraph 48. Also,
Page 40.
or my lord, take straight 49.
Para 49.
Yes, my lord. What follows? My lord, it starts, my lord, what follows?
Yes.
What follows from a conspectus of all aforesaid decisions, we are deciding all the previous decisions, is that jurisdiction is the entitlement of the civil court to embark upon an inquiry as to whether the cause has been brought before it by the plaintiff in a manner prescribed by law, and also whether a good case for grant of relief claimed has been set up by him. As and when such entitlement is established, and any subsequent error till delivery of the judgment could be regarded as an error within jurisdiction. The enquiry as to whether the civil court is entitled to entertain and try a suit has to be made by keeping in mind the provision section 9 and relevant enactment, which according to the objector bars a suit. Needless to observe, the question of jurisdiction has to be determined at the commencement and not at the conclusion of the inquiry. Although not directly arising in the present case, we also wish to observe that the question of jurisdiction would assume importance even at a stage a court considers the question of grant of interim relief, which is below GA6 and GA9, where interim relief is claimed in a suit before a civil court, and a party to be affected by grant of such relief or any other party to the suit raises a point of maintainability thereof, or that it is barred by law, and also contends on that basis that the interim relief should not be granted. Grant of relief in whatever form, if at all, ought to be preceded by a formation and recording of at least a prima facie satisfaction that the suit is maintainable or that it is not barred by law. Such a satisfaction resting on the appreciation of the averments in the plaint. This is where I draw my lordship's attention to. The application for interim relief and the written objection thereto, as well as the relevant law that is cited in support of the objection, would be part of the court's reasoning of a prima facie case having been set up for interim relief, and that the balance of convenience is in favor of the grant and non-grant would cause irreparable harm and prejudice. It would be appropriate for a court to abstain from recording prima facie satisfaction on the question of maintainability. So there cannot be a prima facie satisfaction on the question of maintainability. Yet proceeded to grant protection pro tem on the assumption that the question of maintainability has to be decided as a preliminary issue under Order 14, Rule 2. That could amount to an improper exercise of jurisdiction. If the court is of the opinion at the stage of hearing the application for interim relief that the suit is barred by law or is otherwise not maintainable, it cannot dismiss it without framing preliminary issue after the written statement filed, but can at most assign such opinion for refusing interim relief. Similarly, your lordship can say that till such time the interim relief, the preliminary issue is decided, I cannot grant any interim relief. However, if an extraordinary situation arises where it could take time to decide the point of maintainability of the suit, and non-grant of protection pro tem pending such decision could lead to irreversible consequences. Here, my lord, it does not arise because it's a money claim. The court may proceed to make an appropriate order in the manner indicated before justifying the course of action it adopts. It is not a case, it is not a case of demolition that if the building breaks down and tomorrow I find that the court does not have jurisdiction, I cannot put the situation back. It's a question of money claim. In other words, such an order may be passed if at all required to avoid irreparable harm or injury or undue hardship to the party claiming the relief, to ensure the proceedings are not rendered infructuous by reason of non-interference by court. This is the test. And this is what the Supreme Court intended by saying that if you require to file an application, then you can do it.
Even if we do not consider the order of the division bench or of the Supreme Court, but considering this judgment, the court can make a decision.
The reason why I was harping on the division bench judgment is because the fact that the issue that I have raised has weighed with the court. And the court has said that yes, this point requires to be decided because it goes to the root of jurisdiction and affirmed by the apex court. And subsequently, my lord, corroborated by, and subsequently, my lord, Justice Pattanaik and Justice
Majumdar.
Justice Majumdar had also held. So, my lord, in the absence of my learned friend showing that there is an imminent danger, immediately something needs to be done, which if not done, the situation would become irreversible. The application is not for that.
No, at present, who is receiving the rent of those properties?
My lord, the thing is this, my lord, after this dispute that has cropped up from 2019 and
earlier, who is to receive the rents?
My lord, the rent that was to be paid by OTB was paid to me, and my learned friend has got the benefit of it till 2019, if I'm not wrong.
2019?
Till December 2019, my learned friend didn't have a problem.
No, till 2019, he continued to receive the rent.
Yes. All of a sudden, my lord, this person, now, my lord, kindly visualize this situation.
No, it was paid by OT?
OTB. Akrit.
No, it was always paid by him. I have received rent from him.
My lord, I can understand my learned friend is trying to come across legally by trying to say that I do not acknowledge the existence of the persons.
No, question is he acknowledged the rent from you because he does not know that person.
Of course.
He knows you.
Yes.
So from you, he has received the rent.
So
that is up to 2019.
Yes. But it doesn't take away the fact. My learned friend may legally seek ignorance of the fact that there is no privity of contract between me, him and the persons. That's a legal defense. But is my learned friend contending that from 1970, 1985, the day he filed the suit, until 2022, there is no building on the property, there is no rent coming? From where is he getting the money? Of course he knows, my lord. As a landlord, he won't know. As a Shebaith, he won't know what is happening on the property. A কত story building আছে? কত বড় building ওটা? 6 or 7 story. I'm told, my lord, building is standing.
From you, he received till 2019.
Yes. So from 85 till 2019, rent was enhanced. That was paid. He went on receiving.
But from you?
Yes, from me. I am the only defendant in the suit. I brought in the question of this third party, if only if your lordship, my lord, because I was trying to force a settlement. Because as your lordship knows, my lord, I am a government. I keep on saying and I keep on repeating myself in GS6, the opposition also and here also, that till 2019, I have paid this amount. Even, my lord, pursuant
so
to
monthly rent is how much at present?
5
lakhs or not?
I'll have to find out.
5 lakhs or not?
5 lakhs.
5 lakhs.
In terms of the order of court.
That's 5 lakhs.
That is between you and Mr. Dotto. That
Yes.
is.
And, my lord, it is not because, my lord, this is too well settled. Even, my lord, for the timing, let us argue. Let us argue that that there is nobody in the property. I am in possession of the property. And I refuse to pay rent to my landlord. The consequence of that is not by way of an interim relief you did. If a tenant refuses to pay rent to the landlord, that is one of the grounds for his eviction. His notices, his right to continue gets terminated, and he goes on continuing to be liable to pay mean profits for the period during which he did not pay rent, which can be higher than the rent, which is generally higher than the rent. That is the liability. So therefore, there is no law, even if Milord, your Lordship is inclined to go into GA9, ignoring all these previous orders of the court, including the apex court, Milord. Even then, Milord, if I refuse to pay rent, there is no law, Milord, subject to correction, Milord, which can say that you go out forcibly. He has to get
the relief sought for is eviction.
He will get an order of eviction. Even on the ground of default, he will get an eviction. What Mr. Kaur's problem is this, Milord? Mr. Kaur is trying to say is that he has to initiate proceedings, that in any event he has to. And Milord, what is very surprising is, Milord, when I have been crying hoarse that this cause of this suit, this cause of action is dependent on the 106 notice, the cause of action which has come to an end, Milord. And after hearing my arguments, kindly
Page 116.
kindly come to page 116. Kindly come to page 116.
Yes.
Kindly see Meghjit Mukherjee, advocate. His clients is Shonjeev Shah, Shonendra Shah, joint receivers to the estate. These are the plaintiffs. As late as on 31st of January 2022, they are giving a notice to my client for eviction. Kindly, Milord, come to after setting out all those, Milord, clause 2, clause 4, this previous suit filed pending, Milord.
So this suit is pending from 1985.
Yes. And he is giving me a notice again. The original notice is of 1985. Kindly, Milord, compare page 116 with page 40. Page 40 and page 160 within this compilation. Page 40, Milord, is the notice.
Yes.
On the basis of which this suit is pending.
Yes.
Milord, the typed copy of this notice is at
So
page
this
40.
was the eviction notice.
Yes.
And during the pendency of the suit, again notice is issued.
Yes.
That is which page?
Page 116.
Yes.
Kindly see 116, it starts between the same plaintiff and the defendant. Kindly come to paragraph 8.
Yes.
In as much as the tenancy is governed by the provisions of the Transfer of Property Act 1882, my clients hereby terminate the same with effect from 1st March 22 and call upon you to hand over quiet, peaceful and vacant possession of
These are the matters of record in your application, in Mr. Kaur's
This is
application.
a subsequent fact. This 31st January 2022 notice is annexure L to what? Lordship gives me a moment. Lordship, give me a moment. It's a pertinent question. This 100 other application or notice salary. Oh, Millard, I am told, Millard, this is part of records of GA6.
GA6.
GA6 ka ache kina dekhun to ekhane.
No, in your petition it is there.
No, this is, Millard, a compilation of convenience compilation. This contains all the record. একবার দিন তো GA6 জানো জজ সাহেবকে দেওয়ার। Millard, kindly permit me to check it before I. Yes.
কথাটা কিছু বলছিলাম।
Okay. This is there in GS6.
Yes, part of the petition of GS6.
That is during the pendency of this suit, instant suit.
And Millard, rightly so. Rightly so. Because he can't say that my tenancy which to terminated in 1985, in spite of various consent orders being passed and being on record, that anything survives in that suit. So, this would, Millard, also be a relevant issue or relevant fact to be taken into consideration while deciding the preliminary issue, where I contend that there is no cause of action left in the old suit. এটা কি 11/4 কোনটা এটা তো অর্ডার 7 এখন তো প্রিলিমিনারি এনিওয়ে ঠিক আছে দেখো
দুটো সেপারেট দুটো অ্যাপ্লিকেশন সেপারেট কম্পাইলেশন
In the earlier suit regarding the administration of the estate of the Devotur estate, leave was obtained from the court to sell the property. And thereafter
lease out
the property.
lease out the property.
And it's a leasehold property. What is the period of lease?
Initially, Millard,
81, I think, from 1981.
49 years 49 years
From
49 years from 1980
81.
Millard, that your lordship will find if your lordship takes the list of dates, page 3, compilation.
lease is due to expire on 31st March 2029
29.
by a flux of
That
time.
year, I've recorded that.
So
Now,
this is your termination and lease is due to expire on 2029.
In usual course, the lease would have expired on in 2029.
Assuming there would have been no termination.
No termination.
kindly come to page 3 of the compilation.
Page 3, yes.
4th February 83, lordship gets the date.
1/4/1980. Okay, there is an option of the lessee for further renewal. That option is there.
That option is there. And this terms of this lease, Millard, by orders of court has also been modified. And I had shown Millard the order of Justice Ghosh, which your lordship will find at page 6.
Page 6
of that list of dates.
No, page 6 of this compilation, I believe.
Yes, Millard. This convenience compilation is of pages which, Millard?
Page 6.
Page 6.
Yes.
My lordship will
Oh,
find
extended the time for construction.
then an order by consent of parties was passed in GA 1534 of 2002 and GA 3165 of 2002. The Honorable Justice so-and-so recorded that the matter had come up for discussion and in terms of the negotiations between the parties. It's recorded in that order. I'll take your lordship. The court had recorded certain terms which the parties had agreed. The relevant terms are as under. The defendant, after demolishing the existing structure, shall start the new construction at the said premises within 2 years from the date of this order and complete the construction up to optimum height permissible for construction of the new building within the extended time of 5 years from the date. Kindly similar next. The rate of monthly rent was enhanced to 1 lakh in place of 33,000 during the period April 22 to till March 2008. And thereafter at 3 lakh per month from April 2000 with increment at the rate of 10% every 6 years till expiry of the lease. Suit is adjourned for 5 years from May 2023. If it is not, if I cannot do it, the defense will be struck off and the suit be transferred to undefended list. The defendant complies with this order, it shall be sufficient compliance of the deed of lease dated such and such, and after 5 years the plaintiff shall get the suit struck out. So, my lord, if this is what the parties had agreed as recorded in the order, which is at pages 65 to 74 of that compilation.
Yes.
My lord, if I may ask myself this question, what remains of the suit, of the original?
That is also a question of maintainability.
Yes, I am.
That is a question of maintainability. Only thing is this, regarding these decisions you have cited and with regard to the division bench and apex court order, where
Yes.
this court should
And-
go into
and
that
the fact that-
maintainability.
Yes, and the merits of the matter, my lord.
Whether it is maintainable or
Because,
not.
my lord, if your lordship ultimately is satisfied that there is a question of issue to be tried, I mean, there are two options left with us in law: either to have it tried, or, my lord, not to grant any interim relief till such time it is tried. Because you cannot keep this issue, because that is my defense, you cannot keep this issue side and say, no, I go on granting relief. That is the reason.
Even if you have dealt with this maintainability point in your written notes, that will also be considered
Yes,
prima
my lord.
facie.
Yes, yes. Oh, my lord, this, my lord, just one paragraph, then I will. My lord, kindly come to this judgment reported in 2004 11 SCC. নোটটা দিন তো ওই পাতলা নোটটা যেটা তিনটে জাজমেন্ট।
This is written notes on behalf of defendant.
Yes.
Page
16.
Page 16. It is up to 1 to 10. Oh, page 16. Okay. Yes.
It starts with the judgment of Shipping Corporation of India versus
page 16. Yes. Yes.
Millard, it starts with the judgment reported of Shipping Corporation of India. Kindly, Millard, come straight to page 27, paragraph 25.
Yes.
Thus, it is clear that any subsequent event in the original proceeding, the subsequent event, if the original proceeding has become infructuous, it will be the duty of the court to take such action as is necessary in the interest of justice, which includes disposing of infructuous litigation. For the said purpose, it will be open to the parties concerned to make an application under section 151 to bring to the notice of the court the facts and circumstances which have made the pending litigation infructuous. Of course, when such an application is made, the court will inquire into the alleged facts and circumstances to find out whether pending litigation has in fact become infructuous or not. Having thus understood the law, we will now consider whether the courts were justified in rejecting the application filed by the appellant herein for dismissing the suit on the ground that the same would become infructuous. In this process, we have already noticed that there seems to be no dispute that the original termination based on which suit 4212 of 1995 was filed has since ceased to exist because of the subsequent termination notice issued on 22nd August 2001, validity of which has already been challenged by the respondent in the third suit. So that was the issue there. This was the issue here also. Kindly come to paragraph 31 now, the conclusion. For the reasons stated above, we are of the opinion that continuation of the suit which has become infructuous by disappearance of the cause of action would amount to an abuse of the process of court, and the interest of justice requires that such suit should be disposed of as having become infructuous. The application under 151 in this regard is maintainable. So in either form, whether preliminary 151, I made an application under Order 7, Rule 11, the court said no, I cannot go. And here, my lord, we fit into the case, my lord, there is also subsequent termination which says I am terminating your notice in your tenancy from 2022. Yes. So, my lord, if I may ask myself this question in the teeth of that subsequent notice, it itself shows that they themselves treated the suit to have become infructuous, the tenancy to have continued, because a terminated tenancy cannot be terminated once over. So they themselves by their conduct have showed that it was not terminated.
You have taken this point in your opposition of this 9, GA9. Have you taken this point? This
Yes.
notice in GA9?
Yes. In our written notes also we have taken this point, that there is a subsequent notice.
Yes,
Those would be.
that's all.
May I? Lord, GA9, I have not asked for any fresh relief in the suit. There were existing orders passed by the court directing the defendant to go on paying. There is a stoppage of payment of rent. Therefore, I have filed first GA6 and subsequently post order of the Supreme Court GA9. Now, Lord, this is not, Lord, asking for any fresh relief in the suit.
Or earlier order regarding payment was passed in which year?
Lord, the first order was passed on 22nd May 2003, and Lord, subsequent order was passed on 21st May 2009, pursuant to which there is a supplemental lease deed executed between the parties on 5th of August 2010.
Right.
So, Lord, there is no disruption with regard to the relationship between the parties, because they were directed to carry out certain obligations. Our contention is till date that obligation has not been discharged. That's on merits.
And that they have continued in terms of the order of the court.
Order of the court till December 2019.
Till December 2019.
Yes. Now, Lord, my application, both GA6 and GA9, is only in aid of that continuance of that order. This is what my claim in GA9 or GA6 is. This is first point. Now, Lord, on the question of framing of a preliminary issue in terms of the order of the division bench. I request your lordships, my lord, kindly read the order of the division, Supreme Court. Because, my lord,
Let us first come to the order of the division bench, thereafter Supreme Court.
Lord, I tell your lordship why. Yes, first kindly take
Page 100 and
Lord, the division bench's order.
you have filed your compilations.
Lord, this is the compilation. We will rely on this. I am only relying on the orders.
Mr. Dotto has filed his written notes as well as compilation.
We have filed our written notes. We have not given any compilation. Written notes are
written notes.
it's there. Written notes are there.
Any compilation or list of dates?
List of dates is there. Mr. Dotto has given. I'll
Yes, that is there. So this is your written notes of argument.
Yes, this is my written notes of argument. But give me 5-10 minutes to deal his points.
Now let us come to this division bench judge.
Division bench judge. Let us not see the order of the division bench. 10. Yes, 102. No, it's in the compilation. Let us show him from the compilation 171. I think, Lord, 168 it starts.
171.
168 it starts.
Yes, yes.
Lord, it is an application under Order 7, Rule 11, which was dismissed by the learned trial judge. So, Lord, division bench. Kindly, Lord, come to page 171. That's the page Mr. Dotto has read. Let me read it also. May I read this page 171? Or, Lord, please come to page 170, 170.
Yes.
Kindly, Lord, come to the second last paragraph, sentence starting with the word either as a result of subsequent development. Has your lordship found that?
Yes, yes.
As pleaded by the appellant defendant in the said application, the suit had become academic and nothing remained of it, or it had not become so, and the suit ought to be tried and determined. If the answer is in the affirmative, with regard to the first proposition, then subjecting the parties to a long-drawn trial would be contrary to notions of justice. It is true that whether the suit had become a spent force or not could not be decided in the application under Order 7, Rule 11 or under Section 151 of the Civil Procedure Code. So the learned judge, the division bench agrees with the finding of the learned judge. Then Order 14, Rule 2 is taken note of. That is set out. Kindly, my lord, turn the page. Order 14, Rule 2 is set out. And then, Lord, the sentence, Lord, starting with the word if the suit. Has your lordship got that?
Yes.
Lord, I read, Lord, page 170, the second last paragraph. And then, Lord, kindly see this. If the suit has become academic and infructuous, it goes to the jurisdiction of the court. The court would no longer retain jurisdiction to adjudicate it. Once it is a jurisdictional issue, it can be tried as a preliminary issue before all other issues. This preliminary issue may not be only an issue of law, but an issue of fact and law rolled into one. We are of the view that the question raised in the application before the court below in GA 8 should be tried as a preliminary issue in the suit on the basis of the application and affidavits exchanged thereto before the suit proceeds any further. So, Lord, definite direction by the division bench that this should be, before the suit proceeds any further, this should be tried as a preliminary issue. The learned single judge may direct documents to be disclosed relating to that issue only, invite evidence to be adduced in court for commission whichever the court deems fit and proper, and decide the question as soon as possible. Depending on the decision of the court on that issue, suitable directions may be made either disposing of the suit or directing that the suit be tried and determined on all issues arising therein. At this stage, Mr. Mukherjee submits there is a pending application GS6 of 2022 before the learned single judge. We say that it should be open to the learned single judge to decide in what order preliminary issue or the pending application is to be entertained by the court. Now, my lord, I just pause here for a moment. Lord, if the relief claimed is not a fresh relief, and it is really, my lord, asking the court to extend its own order, that is the relief, Lord, in the nature, Lord, in say, GS6 and GA9. There is no question of asking for any fresh interim relief. Then, Lord, please see, we request the learned judge to decide the preliminary issue within 3 months from the date preferably. Now, Lord, please come to the order of the Supreme Court. Lord, the order of Justice Mojumdar was passed at a time when Supreme Court order had not been passed. So 173, for the time being, kindly, Lord, ignore. Kindly see the order of the Supreme Court. Order of the Supreme Court is, Lord, at page 186. Or before that, 184. 184. Lord, after paragraph 2, the court says that they are not inclined to interfere with the impugned judgment and order passed by the High Court. Then, Lord, please come to 3. Nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law. Now, Lord, I pause here for a moment. The division bench judgment has got merged with the order of the Supreme Court. There is a merger. Now, my learned friend is trying to, Lord, read the division bench order, which says, leaving aside all points, first decide the preliminary issue. Supreme Court clearly says that trial court will be at liberty to proceed with the suit itself in accordance with law, having regard to the developments which had taken place pending the suit. So, Lord, it is not by way of preliminary issue, by way of deciding the suit itself. And then it says, both the parties shall also be at liberty to file appropriate proceedings before the trial court, single bench, as may be permissible under the law. And if such proceedings are filed, the same be considered without being influenced by observations made in the impugned order passed by the division bench. So, Lord, the court, Supreme Court, was aware of the fact that an issue has been directed to be decided as a preliminary issue without proceeding with the trial. That order is being modified by the Supreme Court clearly by saying that trial court shall be at liberty to proceed with the suit itself in accordance with law.
Now, these are all matters of record. Now, assuming
yes,
this court thinks fit that this court will proceed with the suit.
Right.
What will be the reliefs?
Relief
is seeking at present. For tomorrow, this court wants to proceed with the suit.
Very good. Your Lordship proceeds with the suit, tests my case, whether, my Lord, my suit for eviction survives.
Because your 1985, it was a suit. Thereafter, you have entered into some terms of settlement.
No, this is direction by the court on the basis of suggestion of the parties. That does not alter my, and supplementary deed of lease is post these orders. Supplementary deed of lease of 2010 is executed between the parties post these orders. These are, that is an act of the party accepting.
Anyway, you covered this on the next day because today almost, and another thing, you can come with this decision. Suppose some rights have accrued to the parties and one of the party wants to withdraw the suit or the suit has become infructuous, whether the court shall dispose the suit. There are different decisions on that. Regarding withdrawal of the suit, suppose the court has the discretion whether to permit withdrawal or not. If some rights have already accrued to the parties,
absolutely
come with those decisions.
I
on the
will.
next day.
I will. In fact, Lord, this point which my learned friend is trying to argue today, that suit has become infructuous.
Because tomorrow itself the court wants to adjudicate the suit, whether your client will be in a position to
proceed with the suit. I am in a position to proceed with the suit for the simple reason. Lord, today what is the situation?
And on the basis of the original relief claim.
Lord, today my learned friend is trying to club the maintainability of the suit with this application because he doesn't want to.
Letter also, letter of eviction.
I'll explain that.
You deal with that also.
Yes, yes, I will. Lord, today he is clubbing these two matters only because he doesn't want to pay. He doesn't want to discharge his liability in terms of the order passed by the court. So, Lord, all these excuses are put forward, and Lord, they are trying to scuttle your lordships from passing an order securing the default which has happened in the meantime. This is Lord, this is the whole crux of the matter. For this, I don't need to have the preliminary issue adjudicated, because there was an order which was continuing, and I am seeking a continuation of that order. This is my scope of my application. Lord, whichever day.
I'm continuing. So the matter is not that easy what we thought before. Some
Lord,
points are to be-
it is only complicated by my learned friend. Otherwise, Lord, it is simple as water in so far as I am concerned. I am seeking extension of an order which has been discontinued at the whims of a party.
Anyway, you deal with that your client's letter, that
I will.
eviction.
I will. That doesn't change the situation.
And
That
now-
doesn't change the
and
situation.
probably Mr. Datta has furnished you the documents also, these compilations also.
Yes, yes. And the judgment that he has cited.
You deal with them
Yes.
on the next day
Yes.
and come with these decisions regarding court's power to permit withdrawal
Yes, yes.
when some rights have already accrued.
That Mr. Kaur's client is going on making application after application.
And you are
I am the-
defending it.
And I am responsible for
So
completing.
1985, both of you have done so from 1985.
Not only that, if he pays today, there is no complication. That's the simple thing that I have asked. There is an order of court subsisting. That order has not stopped him from paying. If there is an injunction restraining him from paying, I wouldn't have asked.
You deal with all these things, okay? In your on the next day, you submit.
Give me a date, Lord. Whichever.
You submit with regard to the decisions he has cited.
Yes,
and
yes, I will. I
clarify
will
the
deal with his
position.
cases.
Okay, learned advocates for the parties have submitted but could not conclude the same. Let this matter appear. Shall I keep it next week?
Any day that is convenient.
একটু দেখুন তো 28 তারিখে 28 29 কি আছে
28th is
28 কটার সময় দুটোর সময় আছে কোনো ফিক্স 28 তারিখে 28 তারিখে দুটোর সময় 29 তারিখে আচ্ছা 30 আবার তাহলে 31 যেতে হচ্ছে 31 2 PM আছে না তাহলে 31st 31 7 2025 at 3 PM.
Yes. 4 PM matter which was fixed.
Yes, yes, just a minute.
Excellent.
Okay, 3 PM on 31st.
But Lordship is one comment. Yes, yes.
Yes, call the 4 PM matter.
Obliged. Nineteen.
19. Item number 19.
Item number 19, my lord, this is a matter where it is a probate proceedings, rather a proceedings for letters of administration. This matter, my lord.
So Mr. Rai is appearing.
My
Well, we have proved the way the attesting witness was here. There is no one to oppose.
Now the question is, in this case,
Yes,
it is a non-contentious.
Non-contentious
Yes,
matter.
my lord.
And have you examined the attesting witnesses?
Yes, my lord.
The attesting witness has come. Yes, my lord. Attesting witness has come, proved his signature and the signature of the testator, my lord.
It was
Okay.
before my lord, my lord.
So that
This
is done.
Deposition. Yes, ma'am.
Yes, yes.
And those wheels and the signatures are all exhibited.
All exhibited, my lord.
And my lord, we have also prepared a note. If your lordship wants one to be granted.
I'm just taking a printout in bond paper and submitting to my lord, indicating the question numbers, the fact that the will has been proved, the fact that the attesting witness presence has been proved. It is a registered will. And also the fact that the attesting witness has identified all the signatures and has also identified
One
his
attesting
affidavit.
witness was examined.
One attesting witness.
Okay. Yes, record an order.
Written notes on behalf of
Mr. Rai, learned counsel for the petitioner, is present along with Mr. Singh, his junior. Hard learned advocates on the petition for grant of probate. Hearing is concluded. Let this matter appear for orders on 2nd August 2025. You file your written notes of arguments.
Today itself I shall file.
We'll do that, my lord.
2nd August for filing,
Date
the
will-
2nd August for orders,
I
For
shall-
orders, my lord.
and it is a working Saturday. Okay, 2nd August.
Yes, my lord. Grateful, my lord.
Your lordship, praying for one indulgence.
Yes.
Only one thing, it has been recorded as a probate, but it is for letters of administration.
Acha, the application, hard learned advocates on the application for grant of letters of administration.
I'm filing the note here.
Yes, yes, yes,
Within
please.
5 minutes.
Yes.
For indulgence, my lord, I have applied for certified copy, but somehow inadvertent mistake for drawing up and complete is not complete in 7 days. If that leave be granted, my lord, otherwise I won't able to apply certified copy.
So when did it expire?
Order was passed on 1st of July, to be very candid, my lord. I have applied certified copy, but the drawn up and his leave is
Okay,
not
leave granted.
grateful.
Your Lordship, I'll take less than a minute for your indulgence. Yesterday, my Lord was pleased to say that he would pass the order. This
Which case?
item number 41 has been pending.
41?
For 3 occasions, we have served the notice on the other opposite party. They are not appearing. I have filed the GA. The counsel has verbally mentioned that he's not briefed on the matter anymore.
Okay, try tomorrow. Let us see tomorrow. If
If
we
only
can reach tomorrow, I'll take it up. If we reach, definitely it will be taken. Otherwise, next week I shall fix this matter.
obliged.